It is a good segue, Alex. Maybe you can describe what's, these somewhat controversial programs, 702, 214, the policies, Executive Order 12333, and sort of what the intelligence and the concern that Laura has raised of the bleeding over between intelligence and criminal investigations, and what the Office of Director of National Intelligence and other agencies have done to sort of balance, if possible, privacy rights to the right to gather this information.
Thanks, Sandy. So as you pointed out, I'm with the Office of the Director of National Intelligence. For those of you in the room who aren't following all of the national security ins and outs as much as some of us up here are, this was an office that was created post 9/11 by the Terrorism Reform and Prevention Act of 2004 to better lead and coordinate what are now 17 elements of the intelligence community. There have been 4 directors of national intelligence since I have been there, since stand-up of the OD&I. I've been there since the office first stood up. And I've worked for all 4 of them in this capacity. The 5th, Senator Dan Coates, just was voted out of committee in terms of his confirmation for his nomination. He was voted out of the Intelligence Committee. I believe that was yesterday. So looking forward to working for the 5th Director of National Intelligence. My office name was changed recently. It used to be Civil Liberties and Privacy. It's in the statute. I am, by statute, the Civil Liberties Protection Officer. And we added transparency, given lessons learned over the last few years about the importance of coming out and being more public. You had joked earlier that you were finally going to get to me. Pre-transparency, probably a lot of folks in my community would have been very happy if I was just seen and not heard up here. They said, oh, that was successful, Alex. You didn't say a word. But now, of course, we have to engage a lot more, and I think it's very important that we do. You mentioned there's been a great discussion here on the 4th Amendment and all the different laws that apply. One that Laura just was alluding to most recently is the Foreign Intelligence Surveillance Act. It's a very complicated statute. It's been around since 1978. And it's been amended several times. In essence, if the intelligence community wants to target a United States person, which includes Americans, permanent residents, U.S. associations, and corporations incorporated in the U.S., for surveillance search, the kinds of things that implicate 4th Amendment, we have to go to the Foreign Intelligence Surveillance Court and get a court order showing probable cause that that individual is an agent of a foreign power. I'm paraphrasing. I thought it was interesting in the last couple of days with all the news coverage of Foreign Intelligence Surveillance Act that the transparency efforts are, I think, working. There's a lot of interest over the last few years in the Foreign Intelligence Surveillance Act, and I actually thought the media coverage of what the FISA requires was relatively accurate. So I chalked that up on the plus side for the last couple of days. So one important part of that act is coming up for reauthorization. It sunsets at the end of this year. As Laura was mentioning, this is referred to as Section 702. This is something that was put in place in 2008 in an effort to adapt to changes in technology. So we've been talking a lot here about how technology impacts 4th Amendment jurisprudence and also whether statutes can keep up. And basically what happened in 2008 was Congress felt that the FISA, as originally enacted in 1978, needed to be updated. And if you look at the 1978 version of the Foreign Intelligence Surveillance Act, which is still in effect, you'll see the key provision for your purposes or for our purposes is really the definition of electronic surveillance. And I've always hated when people put real important stuff into a definition, but that's where it is. And there are 4 definitions of electronic surveillance, and that essentially outlines the scope of the protections of that part of the statute. So it's sort of very technology specific and uses terminology that is not really in common use these days. And so when 702 was enacted, they tried to use technology neutral terms. If the intelligence community wants to target a non-US person, a non-American, non-permanent resident, reasonably believed to be located outside of the United States for foreign intelligence information with the assistance of a service provider, there's a whole process that needs to go through that gets with procedures that have to be reviewed and approved by the Foreign Intelligence Surveillance Court. The intelligence community feels like that's a very important and valuable intelligence authority that has allowed us to assist in our counterterrorism and national security efforts. There's also another statute you should be aware of called the USA Freedom Act. And the intelligence community supported the passage of that act. That act ended what was previously called the Section 215 telephony metadata program that was being operated by NSA. So NSA has now phased out that program. Under that program, NSA was collecting enormous amounts of domestic phone call records. We called it telephony metadata, but it was querying it only on a very narrow basis. We've published the numbers of U.S. person identifiers used to query. Now I'm blanking on whether it's all identifiers or U.S. person identifiers. It's all identifiers. All identifiers used to query that data, and there were in, 1 year it was 100 and some, another year was, I think it was 400 and some. And that was initially, we amended how we were doing that to require a court order identifying reasonable suspicion before we could use an identifier. USA Freedom Act says basically that data has to stay at the providers and provides a new mechanism by which we can submit the identifiers that we want queried to do contact chaining, call detail record chaining to the phone companies and get the responses back. USA Freedom also requires us to publish, to review FISA court opinions for significant and novel interpretations of the law. It also creates a panel of cleared amicus, of which Laura is one, and who have the clearance to come in and argue, to see the classified information and argue privacy and civil liberties, equities before the Foreign Intelligence Surveillance Court. So there have been some named that have already been named, and some of the stuff has already been published. I'll just end by saying for this part of the, we have Executive Order 12333, which is another thing that adds to some of the complexity in this space. That's an executive order that directs how intelligence community elements are supposed to operate. It gives them each responsibilities in Part 1 of that order. Part 2 includes protections for how we deal with U.S. person information, collection, retention, and dissemination. Agencies have been updating procedures for how they implement that order. The order requires each agency to have procedures that are approved by the Attorney General in consultation with the Director of National Intelligence. And recently have been updating and publishing those as well. So transparency has been a big push, a big emphasis of mine. One of the things that we have found certainly over the last few years is that having robust oversight is absolutely necessary, and for that oversight to consist of people with the clearances. So in essence, it's quote unquote secret oversight. That's a good thing for democracy. You want people to have access to the most secret things we do, and not just us looking at it. You want outside entities to look at it, the Foreign Intelligence Surveillance Court, Congressional Oversight Committees, the Privacy and Civil Liberties Oversight Board, which I'm happy to talk more about if people are interested. But that's not sufficient. We also need to have more public discussion, more public understanding of what the rules are, how we are implementing those rules, and what the heck we're doing. But at the same time, we have to maintain operational effectiveness and obviously keep sensitive information secret.
So in the real world, Josh, how does this play in some of the cases that you've done? And how it bleeds over into criminal cases?
Right, and I'll skip the sort of pure national security aspects of it and talk more about what I think has an impact on white-collar practice going forward and already in some respects, which is that, as Laura mentioned, these national security databases, which hoover up everything to a certain extent in the world, are now being queried for investigations unrelated to national security. So if the U.S. is intercepting communications overseas for non-U.S. persons, that is now available without any Fourth Amendment protection, just FISA statutory protection, which is very weak in terms of FISA litigation is zero success for defendants in the nearly 40 years, zero. So in that context, consider it basically within the government. The other part of it is that the internationalization of this process is threatening as well, because what other governments collect outside of the Fourth Amendment context can be shared with the United States without any impediment altogether, because you don't have any Fourth Amendment right, essentially, for the for another country's intrusion onto your digital privacy, either in communications or otherwise. So if you go to another country, or if someone comes here from another country, or even U.S. citizens, as we've seen in recent weeks, and your devices are copied or cloned, or your devices are seized and analyzed or examined, if you do it in the UK and they do it, it can be shared with the United States without any Fourth Amendment implication whatsoever. So if you think in terms of business activity internationally, in terms of not only communications but also travel, it's an extraordinary exposure for information. If you think about the border, and this is one of the things I want to talk about in terms of Fourth Amendment at the border.
Which is what Orin is the expert in.
Yeah, and I don't think of the border as a safety mechanism right now. It's really a collection mechanism for information in that context. So that you think about if you have a client traveling to the United States from overseas who's not a U.S. citizen, who's not a legal permanent resident, think what that exposes them to in terms of information capture. If you have an expert witness or an investigator traveling to the United States or overseas, think about what that means in terms of their information. I have, on occasion, gone to countries where I've rented a laptop, and this is sort of the old days. Now it doesn't really matter.
So you rented a burner laptop?
That's correct. I rented a burner laptop because we believed that we were going to be essentially cloned in one form or another, in this other country. So these are considerations that are practical. They're Fourth Amendment in the context of what the lack of Fourth Amendment protection means in terms of the exposure of this information to government for all sorts of purposes, not just national security. In the context of national security itself, the USA Freedom Act is the direct result of the exposure by Edward Snowden of the dramatic capacity for collection, storage, aggregation, and analysis of basically every phone call in the United States. And in that context, and sort of the essentially unrestricted in terms of time, in terms of use for much of this information, and a decision by the Second Circuit Court of Appeals in response to that, I think in many respects, which is the Clapper case, CLAPPER, and it was about the program of the telephony metadata collection program. And the Second Circuit, while not deciding on Fourth Amendment grounds, they decided on statutory grounds, did recognize the importance of metadata in the context of some distinction between simply collecting it, aggregating it, and analyzing it, and also in the context of emerging Fourth Amendment analysis. So I think it was a recognition. You wanted to say one thing, and then I want to get to the border.
Yeah, I left border earlier for Orin to address. He's the expert on border, really, in the whole country. He knows this so well. But before we get to that, I just want to make two brief points. One is on general warrants. So, the founding generation, the Revolutionary War was fought in part over general warrants. I've written about this in an article that came out with the University of Chicago Law Review just in October of this year, where I go into detail on the history of this, how it came from Lord Cook and Hale and Hawkins. They rejected it in England. The colonists thought this would travel with them when it didn't. We actually objected, and Otis's oration in Paxton's case is one of the most famous orations in U.S. history, where he decried the British king's use of general warrants. And John Adams, our second president, who was there at the time, he later said, then and there, the child liberty was born. Right? This was seen as the first act of defiance against the crown. Well, what is a general warrant? A general warrant is a document issued by a court or by the executive, which does not name a particular person, does not specify a particular place to be searched. It does not provide any evidence of criminal activity. It's not sworn under oath, and it's used to find evidence of criminal activity. It's actually used to find criminality. It's not presupposed by criminality. So when one looks at the national security law changes that we've seen, 702 PRISM and upstream collection, or one order with 90,000 targets listed on it, this idea that we're just monitoring everything crossing internet backbones, this looks a lot like a general warrant. The Section 215 order did not name a particular person. It did not name a particular place to be searched. It was being used to collect telephony metadata over nearly a decade with no evidence of any criminal wrongdoing, no oath or affirmation, and it was being used to find criminal activity. These are general warrants, and this is in part what the revolution was fought after and what became encapsulated in in the Fourth Amendment. So all the new states incorporated Fourth Amendment equivalents to stop general warrants. And after the Constitutional Convention in 1787, 5 states said it was only with the understanding that a new clause be added to the Constitution prohibiting general warrants, that they would agree to the Constitution. That became the right of the people to be secure against unreasonable search and seizure. The unreasonable meant against the reason of the common law. That's what unreasonable meant at the time. It wasn't this relativistic post-Katz framing that we have. It meant it was against the common law to engage in general warrants. So the first point that I would make is that technology is once again allowing for general warrants to proliferate in a way that really changes the relationship between citizens and the state and greatly expands governmental power. The second point that I wanted to make with regard to Josh's statements and the kinds of cases Josh is seeing on the criminal side. In a case called Clapper versus United States, Justice Alito in that case said that the reason why he wasn't going to handle the constitutionality of FISA-derived information was because if a criminal came forward, so in that case they found that the individual didn't have standing to actually sue for the constitutional underpinnings of surveillance collection because the government didn't have to say whether or not they were put under surveillance. And so Justice Alito said, look, if that happens, if there's 702 derived information, the criminal defendant will be told this at trial and then can challenge the constitutionality of the 2008 FISA Amendments Act. But then it turned out, after the Snowden documents came out, there was a bit of a back and forth when Dianne Feinstein publicly started talking about all these cases where 702 derived information had been used. And members of the criminal bar said, well, wait a minute, that sounds a lot like my case, but my defendant never said that, was never told that 702 derived information was used. And it turned out that, in fact, although the Solicitor General had told the court that defendants would be told if their information came from 702, they weren't. The policy within DOJ was not to tell people that 702 derived information had been used in their trials. So apparently now they will be told, but the concept of what derived from means is still classified. So we actually don't know if evidence that's used in criminal trials has actually derived from national security information. And if you add to that the wall coming down, so right now the government can use FISA even where the primary ends of the investigation is criminal in nature, as long as there's some foreign intelligence component to the investigation. And beyond that, information obtained from these programs can be queried for unrelated criminal purposes, even though there are different and lowered standards for national security. They can now be used to try to find evidence of criminality. And I would argue that together, what we're seeing again is a general warrant. It is a broad collection of information without any evidence of prior wrongdoing that's being mined and analyzed and used to try to find evidence of criminal wrongdoing. That was an anathema to the founding generation, and it continues to be a violation of the Fourth Amendment.
So Nathan, is there Nathan and Alex, or Alex, you want to say something?
So I'm not going to get into a discussion with Laura on general warrants. You're obviously an expert on that stuff, and I don't pretend to be whatsoever. But let me just sort of talk a little bit more about these two programs. So the 215 telephony metadata program, which is no longer being done, it's been discontinued. It was, as I said before, a very large-scale, enormous collection of telephone call detail records, of phone records, not the content, the metadata. So it's the content versus non-content distinction. And in the court order that authorized that under the Foreign Intelligence Surveillance Court, they put very strict controls. And I think this is something that we could talk about in terms of where our vision for the law should be going forward with how much data is available around the world. So essentially what was authorized was for the NSA to put this large amount of telephone call detail records into a single database so that they could find connections between phone numbers that they already knew about, which were associated with a foreign terrorist organization, and put that query in. That was called the seed number, and put that query in and see who was in contact with that phone number. And the program was put in place because in the 9/11 Commission report, they identified a gap in our intelligence capabilities to figure out when a terrorist was phoning home. And so this was really an effort to fill that gap. And I understand that all the concerns that have been raised about it, it's been discontinued, but I didn't want the misimpression to be that we had the data and we're mining it for whatever reason we wanted to. There were very strict controls in terms of how that database could be used. On 702, that is not hoovering up everything. It is targeting specific users of what we call selectors, email accounts, phone numbers. We've published the number. It's around 90,000 was the last number. We'll be updating that number coming up. So the issue that Laura is alluding to there, I mean, and I know that other people think, and I don't want to contest like the size of the collection and whether 90,000 is a small number or a big number. These are non-U.S. persons located overseas being targeted for foreign intelligence purposes who are not otherwise on their own subject to Fourth Amendment protections. The critical question that I think Laura and others are focusing on now is to what extent can the government query that resulting data to identify U.S. persons, Americans, who might be communicating with those foreign targets. In other words, if we're going through the take on a foreign target, we may encounter a communication with an American. We have to minimize that in accordance with minimization rules, and I'm happy to discuss those further. I think the issue is, okay, rather than just sort of happening upon an American, we are now using an email or phone number that we know is associated with an American to query the database to extract from it the communications involving that American. So that is covered in the minimization procedures. What Laura is talking about, and I'm sorry if I'm mischaracterizing you, feel free to correct me, but so the CIA and FBI CIA and NSA can only query for foreign intelligence purposes. FBI's minimization procedures allow it to also query for evidence of a crime. And so that's the difference.
Andy, just one sentence.
One sentence, and then Nathan, if you want to say anything.
Just that
He doesn't.
it does not take a leap of imagination to connect the terms foreign intelligence, the ability to intercept communications of foreign persons for foreign intelligence collection purposes, and FCPA investigations, which always involve foreign governments.
Orin?
On this question of general warrants, I think Laura has to be right if a Section 215 order or 702 order counts as a warrant, that it's a general warrant. And the reason is simple in the text of the Fourth Amendment. No warrants shall issue but upon probable cause. These are court orders that no one claims are based on probable cause. And so if they're warrants, then they clearly violate the Fourth Amendment. The trickier question is, are they warrants? So the traditional answer would be that there are a lot of court orders based on less than probable cause, anything from a 2703D order to various forms of subpoena-like authorities, pen register orders that we say are not warrants, and that's why they wouldn't violate the Fourth Amendment limit on general warrants. So I think the important question is not, once it's a warrant, is it a general warrant, but is it a warrant, and how do you know what counts as a Fourth Amendment warrant? Sort of what's the theory of warrants that's animating the Fourth Amendment?
So one of the exceptions to the Fourth Amendment has been the border search exception. Essentially, once you get to the border, you don't really have Fourth Amendment rights. And the question, Orin, is does the digital age require that we re-examine that exception, particularly as it has to do with electronic communications like we deal with every day?
Yeah, so this is something courts are struggling with, and let me give you a little bit of the history of the doctrine as it applies to computers. So we started getting cases involving searches of computers as they cross the border. This is physical devices. Maybe 10, 15 years ago, the early circuits, two circuits said, yeah, no big deal. Computers are just like any other package, and we can search a package as it crosses the border. Therefore, you can search a computer as it crosses the border. In 2013, in United States versus Cotterman, the Ninth Circuit introduces a new distinction, which is a different rule is required for a forensic search of a computer instead of a manual search of a computer. Apparently, the distinction, not totally clear in the case, is between the use of forensic software like EnCase that one of the programs that law enforcement often uses, to search a computer, which of course would allow search through deleted files, slack space, all sorts of, all the data that's stored on the electronic storage device that the user doesn't normally see or encounter. Search of that material using a forensic tool would require reasonable suspicion. A manual search, which I think is just the agent looking through the files, using his fingers, that does not require reasonable suspicion. That's the Ninth Circuit doctrine. Other district courts have taken it different ways. There's a district court case, United States versus Kim, from DC, which suggested a totality of the circumstances inquiry into the reasonableness of a border search of a computer. That did not get appealed, so that was just a trial level case. Now, post-Riley, a couple defendants are arguing that the border search exception should not apply at all to the search of physical devices. So there's a case, United States versus Vergara in the 11th Circuit, that was just recently completed the briefing, a forensic search of a cell phone across the border, and the defendant is arguing under Riley that there's no border search exception for computer storage devices on Riley's reasoning. So searching so much information, just like there's a bright line rule that a warrant is now required for searches incident to arrest of a cell phone, that same rule should be applied at the border. That's an issue that's been briefed. We haven't had our oral argument or decision in that case. My own sense is there's probably room. I think some courts, I'm a little skeptical of anything that's the only circuit decision is a Ninth Circuit decision, just with all respect to those from the Ninth Circuit. The Supreme Court treats those as like cert petitions,
I wonder
effectively.
if Judge Breyer is still around.
So maybe the Supreme Court will agree with that framework. It's hard to know. The result in Riley was very surprising, even after the oral argument. So hard to know if the Supreme Court would adopt that approach of some heightened suspicion, not just anything goes at the border. I think it's less likely the Supreme Court would ultimately say that there's no border search exception, in part because, for computer searches rather, in part because if you say that, then since the government has few investigative powers to investigate outside the United States, and if you have a warrant requirement as soon as the computer comes into the United States, that means it's actually pretty easy for somebody who wants to put evidence on a computer to put it on the computer in a way that avoids searches entirely. So you can see the border search exception in some ways as a way of compensating for the government's lack of investigative capacity outside the United States, basically saying the government normally can't look out there, and therefore they can look when you come in, and then as soon as it's in, usual warrant requirement would apply, but at the border, special rules. So I'm a little skeptical of the full Riley approach for the border search exception, but I wouldn't be surprised with if other courts adopt something like the Cotterman approach, some heightened suspicion, some reasonable suspicion in those cases. One lurking issue that has not led to litigation is whether the border search exception should apply to purely electronic transmission. So we've been talking about sort of bringing a laptop or a desktop, not desktop usually, laptop or a phone across the border. What about if it's just emailed across the border? Can the government look at that? That has not come up in cases. I tend to think the border search exception should not apply to purely electronic transmission, in part because the justification for the border search exception is the government stopping things from coming into the U.S. that shouldn't come in and keeping things in the U.S. that shouldn't go out. And if the government is just scanning electronic traffic, they're not actually stopping things from coming in or going out. They're just looking at it. They're not fulfilling the function of the border search exception. So I'm skeptical that courts, I think courts should not say there's a border search exception for purely electronic transmission, but that's an issue which we can debate and hasn't actually been litigated.
Has
yet.
DOJ taken a position on that?